A Supreme Court opinion on one of the important remaining cases was issued this morning. It's the Tennessee case about the prescription of puberty blockers to transgender minors. Mind you, this is not just saying you have to get parents' consent. This is whether doctors are allowed to prescribe these at all with the parents' consent. The case is called U.S. versus Skrmetti. Skrmetti is the Attorney General and reporter for Tennessee. What's it about? A Senate bill, SB 1, apparently the most important Senate bill in the Tennessee Senate that year, that prohibits healthcare providers from prescribing, administering, or dispensing puberty blockers or hormones to any minor for the purpose of enabling the minor to identify with or live as a purported identity inconsistent with the minor's biological sex, or treating purported discomfort or distress from a discordance between the minor's biological sex and asserted identity. In other words, prevent prescription of drugs that help some minors. There you go. 3 transgender minors, their parents and doctors, sued, and lower courts were split on what to do about it. The issue is not really whether the Supreme Court thinks the law is a good idea, though that probably plays a part. It's whether the Constitution of the United States prohibits Tennessee from enacting such a law. Why might the Constitution do that? Well, I've got it here. Let's look at Section 1 of the 14th Amendment, something we've been reading a lot lately. Nor shall any state deprive any person of life, liberty, or property without due process of law. We've talked about that a lot. Nor deny to any person within its jurisdiction the equal protection of the laws. In general, to decide such cases, courts rely on a rule called a rational basis test. Is there a rational basis for the law? And nearly always, there is. Remember, we're talking about courts invalidating state laws because they violate the Constitution. In general, the courts would say, yeah, states, legislatures can do what they want, but not always. There are higher levels of scrutiny when we get into so-called suspect classes. We might have intermediate scrutiny, we might have strict scrutiny, and they all have their own tests. The plaintiffs want to use something more than rational basis. Why? Because they say that these are suspect classes, transgender people, who deserve a higher level of scrutiny. You would have a higher level of scrutiny, for example, if you had something that was based on sex. For example, saying men can do this, but women can't, or vice versa. That might warrant a level of higher scrutiny, not just rational basis. It's a higher burden placed on Congress and state legislatures to justify what it is they're doing, and they can overcome a strict scrutiny basis. Maybe there's a reason for there to be discrimination among different groups, but often there's not. The plaintiffs said that this law really does turn on sex, and the court said it doesn't, that it treats all transgender people and all minors the same, regardless of their sex. The court says that the statute does not apply to people differently based on their sex. It applies to them all just the same. The court said that the rational basis test is the correct test, that Tennessee overcame the rational basis test, and that the proscription on prescribing these drugs is okay. Ultimately, you have 6 justices who would rule that way and 3 who wouldn't. I'll leave it to you to guess who the 6 and the 3 are. There are 118 pages of opinions, and here's how it's split. Roberts delivered the opinion of the court. Thomas, Gorsuch, Kavanaugh, and Barrett joined, and Alito joined most of it. Thomas filed a concurring opinion on his own. Barrett filed a concurring opinion, and Thomas joined it. Barrett did not join Thomas's. Alito filed an opinion concurring in part and concurring in the judgment, meaning that he would find the same way. Sotomayor filed a dissenting opinion. Jackson joined in full. Kagan joined part of it. Kagan filed her own dissenting opinion. Look for more states to now do this. Not just say that you need parental consent, but say that doctors cannot prescribe treatments to minors who are transgender.